Hi, everyone. Welcome back. We are now moving on to chapter 6. So we're still talking about searches and seizures. We're just going to go to the next step in the search and seizure analysis. So last week we talked in chapter 3, we talked about when the Fourth Amendment even kicks in. So we talked about protected areas and then defining search. We're going to take it one step further now, and we're going to talk about the actual warrant requirement of the Fourth Amendment. So I'm going to share my video or my PowerPoint with you, and we're going to go through this today. Okay, so what we're going to do is we're going to talk about the warrant, and we're going to talk about what the Fourth Amendment says about that warrant. So remember when we started talking about defining searches and seizures, we said that if we say it's in a protected area, then we have to make sure it's a search. And then and we said the Fourth Amendment kicks in, the Fourth Amendment analysis, and the Fourth Amendment analysis are these three things. So was it actually a search within the Fourth Amendment? Was the search reasonable? And if it's not reasonable, should it be banned under the exclusionary rule? So remember, we've already done number 3 with the exclusionary rule. Okay, so we finally did the first one last week. So last week we, number 1, had to decide if it was even an area that is protected by the Fourth Amendment at all. So remember, expressly protected, persons, houses, papers, effects. And then we said also the expectation of privacy expands on that protection. So as long as it fits in the definition of expectation of privacy, it will also be protected. So then we went on and we spent time talking about how do we define searches? What is a search? Once we finish that with the second lecture, we've done this first prong. So is it protected? Is it a search? So now what we have to do is we have to move on to the next part of the analysis. Is it reasonable? Okay, so if we determine it is a search, it doesn't mean that it's automatically unconstitutional. Remember, the Fourth Amendment says it protects against unreasonable searches and seizures. So if we decide that it's a search, then the next step is always to decide if it's reasonable. And that's what we're going to talk about today. What makes a reasonable search? Okay, so when we're talking about reasonable searches, we have to look at different factors. So these are the different things that could make it reasonable. Number 1, you have a warrant, and number 2, you validly execute that warrant. Okay, so that's one thing that makes it reasonable, having a warrant and validly executing it. Or you could have a valid exception to the warrant. So what we're going to do this week is we're going to talk about warrant and execution of warrants. And then next week, we'll do the second part of chapter 6, which is exceptions to warrants. So you actually have 2 weeks to get your mind tap done, because we're going to cover chapter 6 in 2 weeks. First, warrant and execution of a warrant, and then next week, exceptions to warrants. Okay, so we're going to break it down into those two. So you will have one assignment for each week, though. You have chapter 6, part 1 due this week, and then next week you'll have chapter 6, part 2, when we go through exceptions to warrants. Just one discussion, though. Okay, so remember, we spent some time talking about the Sixth Amendment, and we said expressly protects persons, houses, places, and persons, houses, papers, and effects against unreasonable searches and seizures. And then if you keep reading it, it says shall not be violated, and no warrant shall issue. So you cannot issue a warrant unless you meet certain requirements. You also can tell from this that it's saying you must have a warrant for the search and seizure. So the word warrant itself is actually listed in the Fourth Amendment. So what the heck is a warrant? All that a warrant is it's a court-ordered document. It's a document signed by a judge ordering that something occur. Okay, so a search warrant is an order to the police authorizing them to search something or someone. An arrest warrant would be a court order authorizing the police to arrest someone. So it's a court order. It has to be signed by a judge. Okay, so let's kind of stop for a second. We know we need a warrant. So how do we get a warrant? Well, let's think about that process. basically, in order to get a warrant, you have to fill out what's called a search warrant application. Now, I have posted the application online under the materials. It's not required, but if you'd like to look at it and try to fill one out and see how hard it would be, because they're pretty hard. A lot of times they just have lawyers that are prosecuting offices or some different special people that fill them out because they're a little tricky. But you can open it, you can look. I have one page is scanned and then the back of it. So it's on 2 pages. I have a little scenario. So if you wanted to try to fill one out just for fun, you could. So you fill out that application and then you take it to a judge and the judge is going to review it. And that's why it's tricky, because if you don't do it right, the judge will not sign it. The judge will refuse to sign it. If the judge does say you did it properly and sign it, then you have to execute that warrant. So then you take the warrant and you go to where you're searching and you present it and you conduct the search. When you do a search and seizure, you have to keep track of every piece of object, evidence, whatever it is. You have to keep track of it. And you need to make a list of everything that you're seizing. And then that list has to be turned over to the judge. So the judge has a precise accounting for every single item that was seized. So you have to list it and identify it and tell the judge ultimately what you seized. You're going to take the actual evidence to the evidence room at the police station, but you're going to have to turn this search inventory over to a judge to show what you took. Okay. Now, since we now know the Fourth Amendment requires a warrant, we have to start thinking about what are the requirements to make it a proper warrant? What are the procedures to follow to assure that it's a proper warrant? So the first thing is that it has to be signed by what we call a neutral magistrate. So magistrate is just another word for judge. So it has to be signed by a judge. And it's pretty important that it's neutral. Okay, so we'll talk about that in a minute. You also have to have it supported by probable cause. We'll spend some time. We already defined it, particular person, particular crime, but we'll get into that a little more. And then particularity requirement. We'll talk about what that particularity requirement is. So let's talk about a neutral magistrate. Okay, so we have this case, Coolidge versus New Hampshire. And in Coolidge versus New Hampshire, the state attorney general issued the warrant. So they didn't go to a judge. They went to the state attorney general. Now, remember, the attorney general for the state or the federal government is the top criminal attorney for that entity. So the state attorney general is basically the top prosecutor or district attorney or whatever for the entire state. So they're going to prosecute crimes that exist within the state. Okay. And what this case said is, you cannot get it from a prosecutor. It has to be a magistrate, it has to be a judge, and it has to be somebody neutral. If it's the state attorney general, then they're the ones that are going to be involved in the criminal action. And so therefore it is not neutral. So the court said, cannot do this. Now, this was a case, Low G Sales, where the judge signed a warrant and said, yeah, but I just want to make sure you're only finding the proper things. So the judge themselves went to the crime scene and was directing police what to search and seize. And the court said, you can't do that. You have to be completely neutral. You have to be completely detached from the proceedings. You just issue the warrant and step back. You cannot be actively involved in the actual investigation process, or that violates the neutrality of the warrant. Okay. So now we've said you had to have a warrant. It says no warrant shall issue but upon probable cause. So one of the things we said is that you have to have probable cause. Your warrant has to be based on probable cause. So hopefully you remember from the very beginning of class, we gave definitions of probable cause. And we said that it's enough evidence to show that a particular person committed a particular crime. So it's around 30%. So you have to be able to point to specific facts and circumstances that establish probable cause before a judge is willing to sign the warrant. Now, depending on what you're asking for the warrant, if it's an arrest warrant, then you have to show precisely this person committed this crime, and that's why we want to arrest them. So that's the definition I gave you. For searches, it's a little different. You need probable cause that the items seized are connected to criminal activity. So you have to show enough evidence to show that we want to look for these items because they're part of a crime, so specific crime. And you have to show that there's probable cause that the items will be where you say that they are. So if I'm asking to search a house, I have to show or prove that the items I'm seeking to search for are going to most probably be at that location. And I have to point to evidence or facts that support that conclusion. It just can't be off the top of my head. I have to actually have some evidence or proof that those things would in fact be there, okay? So that's kind of what you have to prove. You still have to be able to point to crimes, but you have to show that the evidence would be there. So what about this? Would a police officer establish probable cause, or how would a police officer establish probable cause? You can use lots of different things to establish probable cause. Anything the officer knows themselves. So if the officer is conducting the investigation and they found out a bunch of evidence about certain things, they can use that evidence to support probable cause. So our blocks, when we're piling our blocks up to see if we have probable cause, anything that the officer knows out of personal knowledge can be used as a block. So they know this person's a known drug dealer. They know different things. They can also use circumstances gained through an investigation, which means if they found out information from, like, let's say a witness or a witness or the victim tells them certain things, you can use that information also as blocks in support of your probable cause. Okay, so they basically allow both direct evidence, things the officer directly knows themselves, fingerprints, blood, videotapes, anything like that, direct evidence, in order to support that probable cause. But they can also use that hearsay, statements or information that they receive from someone else. That's your hearsay. And you can use both for probable cause. You may not be able to use hearsay as evidence in trial, but you can use hearsay evidence to support an application for a warrant. Okay, so what do you think of this? Officer Smith is walking down the street and observes three men huddled in a doorway. Their heads are close to each other and they are whispering to each other. So we need to think of our blocks. What do we know? We know he's walking down the street. We know he sees three people. We know they're standing in front of a doorway. We know their heads are close to each other. We know that they're whispering. Is that enough for probable cause? We can point to a particular person, particular crime, know that there's actually something going on, and we know exactly what we're looking for, and we know exactly where to find it. So we would have to decide, does that meet probable cause? I would argue no, that that's not enough piled up evidence to reach probable cause. So then the next thing, what about this? What if one of the male hands another male some money and then gives them a brown bag? So you see an exchange of money and a bag. Is that enough for probable cause? So go back again to the definition. Specific person, specific crime. Do we know exactly if there is a crime at all here? And I would again argue no, because just because they're exchanging a money or a bag doesn't mean that there's actually a crime. We may have reasonable suspicion, so we may be able to stop them, ask them questions, do a little more investigation, but we're not going to have enough for probable cause to actually search at this point. What if it's in a high crime traffic area? You recognize one of the males since you already arrested him for selling drugs. Now, do we have enough? And I would argue you probably now have enough, okay? So when you pile those facts on top of the facts that we already have, we probably now can get up to probable cause. And then we could seek a warrant and a search and seize. So what about this? 11:45 in a high crime area, police see the defendant with a known narcotics addict. The suspected addict walks away and enters a building, later returning to the defendant. They huddle together, use hand movements in the huddle, so they're all kind of talking. Police cannot see what is happening. They approach and the men turn away and hurry away. Police testify that this is typical behavior of drug dealers engaged in a drug transaction. So think about it. You're the police. I'm sorry, you're the judge, and a police officer is coming to you, and they know high crime area. They know the defendant is a known addict. You see him walk away. You know he's talking in a huddle, and then you see them walk away when the police start approaching them. And then you know you've had extensive training that this is often typical behavior of a drug dealer engaged in drug transaction. So you have to decide, as a judge, would you be willing to sign this warrant to search them? Okay, so the important thing to remember is there may not be a right or wrong answer. It's the judge's discretion. The judge has to make a determination or a guess of whether or not they think there's probable cause. I would probably sign it. Okay. Now, one of the questions is, can an informant's information amount to probable cause? So we said you can use direct or indirect evidence. We can use hearsay evidence. But what if the information is from an informant? We have informants out there trying to get information. Can that be used as part of our probable cause? So this came up in Draper versus US, and the Supreme Court said yes, as long as the prosecution can show that the informant was reliable and credible, then you can use what that informant told you in order to establish probable cause. But you have to pass this reliable and credible test. So you have to convince the judge that what the informant told you was reliable and credible. Okay, so either you corroborate it or you find another way. I'm sorry, every time I do this, I don't know if I'm talking so much, it makes me a little yawny. Okay, so that is what you would have to do. Now, what's important is what the Supreme Court said for reliable and credible. The Supreme Court created this test called the Aguilar-Spinelli test. And they said an informant's tip can be equal to probable cause or be used to establish probable cause if police can demonstrate two things about the informant. Number one, you have to show that the information itself is reliable and credible. So maybe you have to corroborate it by things you see or like something you know. So as long as you convince the judge that it's reliable and credible. And then the second thing is you must reveal that how the informant got the information. So you have to be able to tell the judge that the informant knows the information they know based on what? You have to convince the judge why the informant knew the information. You had to have both to pass Aguilar-Spinelli, and you had to pass Aguilar-Spinelli and able to use that eyewitness or the informant's information as a block or as evidence to establish probable cause. Okay. The problem was we had this Gates case. Gates came along, and what happened was, the police received an anonymous letter in the mail that said that the Gates were engaging in the sale of drugs. And they told the police in pretty big detail, Mrs. Gates will drive a car down to Florida, pack the car up. Mr. Gates then will fly down. They'll drive back together with the supply and then they'll sell it. So the police see Mrs. Gates leave, fly down to Florida. They track her down there. She's been there. They're kind of following her around. Then they know Mr. Gates she drives down. She's down there for a while. Then they track it and they find that Mr. Gates is flying down there and is going to meet with them. And then they come back and they're in the house. So the police go to the judge and say, we want a warrant to search the Gates house based on what we know. And it's reliable and credible. We know it's reliable and credible because we corroborated it based on our observations. But the defendants said no, because there's a second part of the Aguilar-Spinelli test. You have to say where the information came from. And in Gates, it came from an anonymous tip, an anonymous letter. So the prosecutors were unable to tell the judge where they got the information. So it would have failed under the Aguilar-Spinelli test. Now, the Supreme Court didn't like this much. They wanted the police to be able to use that information. So the Supreme Court overruled Aguilar and Spinelli. They threw it out. And they said, we're not going to use that test anymore. Instead of having to show reliable and credible and where they got the information, we're just going to use what's called the total circumstances test, right? We're just going to look at all the facts that we know. And if there's enough for probable cause, then we're going to say the warrant is okay. So you don't have to show reliable and credible. You don't have to show how they got the information. We're just looking at all the facts together. And if all the facts together in total circumstances establishes probable cause based on part of that information from an informant, we're good. We don't mind. We'll let you use it. Okay. So when they're talking about total circumstances, they're saying you're looking at everything surrounding the crime or the potential crime. So what does the police know? Do the police have general information about what's going on from anything? Is there any forensics evidence that's connecting him? Is there witness statements that are being made, or even the victim making a statement? Does an informant give us some information? So the informant can be a piece of evidence, and we can pile all that up. And based on total circumstances, if we have enough for probable cause, we are going to sign it. So when you pile it all up, does it reach the top rung requirement of probable cause? So would these items make up totality of circumstances? All of these facts were involved. So information from an informant that can be used as one of the factors for the judge to consider. Facts from a criminal investigation, so forensics or anything like that. Any information that we receive from a witness, even if it's hearsay. And all of the police's own knowledge. If they know about the suspect's past or any specific thing, they can use that knowledge. So all of these facts are involved in establishing whether or not there's total circumstances that reach probable cause. Now, one of the things, remember, the Supreme Court makes the line, and anybody, states can give more rights. They can never give less, but they can always give more rights. New York decided to keep the Aguilar-Spinelli test. They decided we're not going to switch the test. We like Aguilar-Spinelli. So in New York, you still have to prove reliable and credible, and you still have to show where the person got the information. So what happens in New York is they'll hold a little hearing called a Darden hearing. And this is where the courts look at what the police have with regards to informant information, and the judge will have to make a determination, is there enough probable cause with what we have? Okay, so that is what happens. You have to meet Aguilar-Spinelli, which is a little harder in New York, and you may have this little hearing to determine if the informant's information is good enough to include as probable cause. Now remember, if you're basing the warrant on probable cause based on informant information, if they kick out the informant information, you probably then will not have enough to get your warrant. So you try to keep that information in so that the judge will sign the warrant. Okay. So we now said warrant, we now said probable cause. Another thing that the Fourth Amendment says is that the warrant has to be supported by an oath or affirmation. This just is a sworn statement. So whoever is making out the application for a warrant has to sign it and assure that everything that's in it is the truth by penalty of law if they lie. Now, there are certain things that the oath or affirmation have to include. So when you're swearing to the judge that everything's correct, make sure that all this information is on that oath. So the person who is saying that they know the information is the person that has to fill it out, the claimant. So it's usually by police or the actual injured party. They have to have specific knowledge of the information in the warrant. We don't want random people being able to swear to warrants. You have to, the person that signs it has to have specific knowledge about the information that it contains. You also have to say where you got the information. So remember, we said it could be the officer's own knowledge, it could be hearsay, it could be things that they learned separately. You have to specify each of those in the warrant. Who gave it to them, how they got it, how do they know, each piece of evidence. The person that fills it out, usually a lawyer, has to testify or swear that there is probable cause, that you believe there's enough probable cause to fill it out. This isn't frivolous. You really think there's probable cause. And then you must convince a judge that exists. So you're going to hand this over to a judge and you're going to say, Judge, please sign the warrant. So you have to convince that judge that there is probable cause to sign it. If you don't prove probable cause, they're not going to sign it. And then you must only get a judge in the district where property or persons is located. So you can't just shop around to any judge. It has to be either where the property is located or the person's located. And that's the judge you want to sign your warrant. Okay. Now, how do you specify probable cause? Is there enough? So you are on patrol and the neighbor of P tells you that P is selling drugs. Asked how he knew. The informant said that the last time he saw people come in and out of the house, and those people are seedy and suspicious. It always looked like they were high on drugs, particularly after coming out of P's house. The neighbor also said that he was in the house one evening last week and smelled marijuana. The informant asked if P moved into 1 year ago, didn't have children, seemed to have no work, and appeared to live well. P's wife refused to associate with anybody, and they said she is simply weird. How do we know if we have probable cause? So what I like to do is I like to start at the top and start listing what you know you have. Okay, so we have informant information. We have a neighbor telling us that P's selling drugs. Then we would say it's pretty much reliable and credible in the sense it's the neighbor and he said he observed it. Okay, so we have the informant information. He said that the informant knew to make him more reliable and credible. He says, I saw people coming out in and out. So we have some direct evidence, people leaving and coming to the house. Now, the informant says the people are seedy and suspicious and always look high. Now, is this a fact or is this an opinion? If we deem this just an opinion, we do not want this included in the warrant. We want to be really strict and just follow the objective reasons why this warrant should be signed. And if you're putting things in about particular people, it doesn't look good. Okay. You also know that the neighbor has seen people come, saw and smelled marijuana one night, and that we know that he saw people move in. They don't have children. They don't work. They seem to live well. And again, then now we're back to they are simply weird. That is probably just an opinion. So when we stack up all the things we know, is there enough for probable cause? So if you're the judge, would you be willing to sign that warrant based on probable cause? Now, once the warrant is signed, the defendant, and this goes and they execute it, the defendant gets a copy. The defendant may have the ability to challenge that warrant and say, nah, there really wasn't probable cause. We know a judge signed it, but we disagree. We do not think there was enough probable cause. We think that that judge messed it up. So then you would ask for a Frank's hearing. So a Frank's hearing is a hearing where the judge is going to evaluate all the evidence around the search warrant and getting the search warrant, and have to make a decision of whether in fact it was a valid warrant or not. If the judge decides it was not a valid warrant, it's thrown out and all the evidence would also be thrown out. Okay, so what if the officer submits an affidavit with information about the location of drugs, but the information is 1 month old? So think about the nature of drugs. Do they stay in one place for very long? Probably not. So we have to think about how old or how long are we going to let this information be to count it towards probable cause. And the court says it must be fresh. Now, they haven't ever really given a specific day or how old it can be, but it has to be fresh enough that the judge can reasonably believe that the evidence is still there. So if it's type of evidence that can move fast, then you have to be more careful because it's probably going to be harder for you to prove that the evidence would still be there. Okay, so when you're checking, you got to make sure the evidence, the probable cause is based on more recent information. Okay, so the very last piece of the Fourth Amendment says that the warrant has to particularly describe the places to be searched and the persons or things to be seized. So this is really, really important. You have to particularly describe. So that means in great detail where to search and what persons to search or seize. If it's not specific enough, particular enough, the judge will not sign it. So when you're writing down what you want to search for, you have to be very careful that you exactly explain what it is you're looking for. So if it's the place to be searched, you want to remove all doubt about what the premises are that you're searching. So let's think about this. You want to search a suspect's house. What's the best way to describe a house so that it will never be confused with another house? How do we list it in the warrant in a way that they know exactly which house they can search? Most likely an address, right? So you're going to list a precise address to clearly identify what property can be searched. Now, objects to seize. So these are what you're going to actually seize. It says things to be seized must be described in detailed sufficiency to narrow the discretion officers can exercise over that item seized. So not only you have to describe where you're searching, you have to be pretty detailed on what you're actually looking for. We're not going to just be able to go on search expeditions and search everything. We can only search for things that are related to the crime. So we have to be very specific and list in the warrant what we're searching for. And it's really important to note, if you don't list it in the warrant, you probably should not be looking for it. It's probably a violation of their constitutional rights. So always make sure that the warrant clearly states what they're searching for. And then the last one are people to arrest. If you want to arrest, it's a search or arrest warrant, you need to sufficiently describe who you want to arrest. Generally, it will be their name, okay? Now, police have in their possession a video from a security camera in the bank that was recently robbed. The suspect, white male, 6 foot tall, mustache, bald head, scar on his cheek, and tattoo of skull and crossbones on neck. So the question is, we don't know his name. So does that mean we cannot ask for a warrant based on probable cause to arrest this man? Or can they arrest them based on the information they have? Is there enough probable cause for the judge to issue it? Okay. So I would say, yes, there is enough evidence or details. So sometimes you may have to describe the person in great detail to eliminate the possibility it's somebody else. You can't just say, oh, brown-haired male. That's too general. So you're going to have to specifically describe it in enough words so that the person would be identified. Since we don't know the name, this is often called the John Doe warrant. It's a description so police know who they're looking for, but it may not be their person's name. And this is just food for thought. This is just something that's come up. In recent years, criminal investigations, police are providing general warrants to Google or Android, things like that, Apple, asking for data gathered within a certain distance from the crime scene. So they know a crime was committed within 5 miles of your house. They go to Google and say, we want all information about Google searches within a 5-mile radius, but I don't have a warrant, okay? So these are super general warrants. They're not detailed at all. They do not particularly describe anything. So are they valid? The warrants do not include specific claims or probable cause or anything bad. They also have a clause that Google is not allowed to notify the users of the warrant. So that's another thing on top of this. They get these really general warrants that just say, we want general information about Google searches within 5 miles of the crime. And by the way, don't tell anybody that we asked for this information or that you gave it. Okay. This is a pretty hotly challenged issue that's going on right now. Are these valid warrants? Okay. Now, if you notice when you get the warrant, you get it signed, and you notice there's a mistake on it, can you just use it anyway? So are you bound by the warrant, or can you just realize, oh, it was just a mistake and just follow the way you need to? So this is an example of that. Police obtained a search warrant to search the premises known as 2036 Park Ave, 3rd floor, for drugs and drug paraphernalia that belonged to a person named McWebb. The police reasonably believe there was only one apartment on that location, but once they go there, they realize there's 2 apartments on that floor. One is McWebb and the other is Garrison. Once they execute the warrant right away, they realize they're in the wrong apartment. They're in Garrison's apartment instead of McWebb. So then without going any further, they leave, but they had located drugs. So they confiscated those drugs before they left. So would the evidence be excluded from a bad warrant? Are we going to allow this? And the courts have said, if you know there's a mistake, you can have the good faith exception kick in if it was a reasonable mistake and you really relied on it. But remember, New York does not rely on good faith, does not use good faith. So if this happened in New York, it's a bad search. So if you're happening to search and you realize there was this mistake on the warrant, stop. Don't search. Go fix the warrant before you search. Okay, so we're going to take all of that and we're going to try to figure out if certain things are particular enough. Okay, so this is just a learning check. So here's a list of descriptions that were on a warrant. What I want you to do is read through each of these and decide, are they particularly describing the things to be searched for in enough detail to leave no doubt to the officers what they're searching? So stop the video, read through each of these and decide particular enough or not. If they're not, what part of it makes it not particular? When you're done, start the video again and we'll see if you got what I got. Okay. So hopefully you did it, and this is what I got. So the first one, unknown make 38 caliber blue steel with wood grip revolver. Yes, I would say that's particular enough. Okay. Videotape and equipment used in copyright infringement. No. What's equipment? Equipment is not particular enough. Equipment could be anything. Equipment for what? So no, this is not going to be particular enough. A doctor's file of patient X concerning an accident. Yeah, you have the patient's name, you know the day of the accident. That's going to be particular enough. Plaques, mirrors, and other items. No. What's other items? That would not be particular enough. Items related to smuggling, packaging, distribution of controlled substance. No. The whole thing is off. Like what? Anything could be used for these things. So that is not going to be particular enough. And then business papers that are evident of an instrumentality of a violation of fraud. No, way too general. That is not going to be particular enough. Okay, so hopefully you see how you have to describe it really, really detailed. And that's why a lot of times they have lawyers or special departments in the police that are doing this. Okay, now it's not as easy as it seems. Like you think, oh, it's easy to write that. Okay, so what I want you to do is I want you to try to do one yourself. Okay, so this is going to be your part 1, chapter 6, part 1 assignment. There's a scenario and I want you to particularly describe the persons and places to be searched and the evidence to be seized. Okay, so I want you to think about these things. Do you have a specific address? Do you have a specific description of a car? Do you have enough detail of the items? So think of all of those things when you're trying to particularly describe something. So this would be your scenario. You've been watching a suspect who you believe is engaged in mob activity, counterfeiting. You went to search his home and office and car to find proof of activities. So you need to word it in a way that you particularly describe where to search and what to search for. Okay, so make sure it's enough details. So that's your assignment. Then the last thing I have is I posted the search warrant affidavit. This is an affidavit. I want you to be the judge and read the affidavit, the application, the warrant application, and you decide if you were a judge, do you think this would be enough evidence to sign the warrant, or are there flaws, and what are those flaws? So that's just a little scenario you can read and practice. Okay, so that's all I have for the first lecture. Again, if you have any questions, just like always, feel free to ask, to reach out. Sometimes this stuff gets confusing. I'm always here to answer any questions that you have on any of the materials. So the next lecture now, once we talked about the warrant, so the next lecture, we're going to talk about how do you properly execute that warrant. So I'll see you for that one. Bye.
Hi, the key word is particularity. The key word is particularity.